Hello and welcome to the Kenneth O'Cannon Law Office Legal Podcast. This edition, we are talking about estates where there is no will. So that's called an administration. Where there is a will, the will gets submitted to probate. The person who's in charge becomes what's called the executor. But if there's no will, then all of the different beneficiaries have to sign what's called a renunciation, saying, I don't want to be the administrator. I will let my sister do it, or whoever else in the family. So if all the beneficiaries sign this renunciation in front of a notary, that gets filed with the county surrogate's office. There's an information sheet for an administration that has to be signed and completed. Then information on assets have to be provided to the county surrogate, typically they have the person who's the administrator has the attorney do that for them. Each county has their own administration form, and then an appointment's made with the county surrogate. Then the person, if everything is in order, then the person who is going to be the administrator has to obtain what's called the surety bond. And that's an insurance policy required under state law that the person who's the executor doesn't, go off and steal the money. But an administration becomes much, much more expensive because the process, the bond costs money, there's many more expenses. So it really saves people money when they have a valid will prepared by an attorney. Afterwards, the administrator has to obtain a tax ID number, open up an estate account, and then do all the different jobs of the administrator, same as an executor. But at the end, it's a little different because all the beneficiaries have to sign a form typically prepared by the attorney called a release and refunding bond. If any of the beneficiaries don't sign it, then the administrator has to use estate monies to have the attorney file what's called a complaint to approve a formal accounting, which then costs thousands of dollars more. So the bottom line is that it's better to have a will than go through the no-will administration process. For more information on administration of an estate where there's no will, visit website njlaws.com. And for representation, contact Ken Burkaman's office at 732-572-0500. Thank you.